Hi, I'm James Dickey, Senior Counsel for the Upper Midwest Law Center, Minnesota's nonprofit public interest law firm that fights for liberty and the rule of law. It has been a busy time for the law in Minnesota, and we at UMLC have been working hard as your voice fighting for you in the courts. We're back now after a brief hiatus and looking forward to delivering you more regular updates on what's going on in Minnesota's state and federal courts. Many in the formerly governing trifecta celebrate the 2023 legislative session, and some, like Governor Walz, boasted about burning political capital. But the federal courts in Minnesota issued preliminary injunctions against one unconstitutional law after another from that 2023 session. Undeterred, the legislature kept up its onslaught on the Constitution in the 2024 session, with even an alleged felon senator casting the deciding vote on a massive omnibus bill of over 1,000 pages that the legislature had about 45 minutes to read before passage. We previously examined the trifecta spotty record in court on this podcast, but now that the trifecta appears to have been broken by the will of Minnesota's voters, we're updating our review of where the cases challenging the trifecta's laws are at. And here to help me with this update is a great friend of Upper Midwest Law Center and sometimes co-counsel, Ryan Wilson. Ryan, thanks for joining me. It's been good to battle alongside you in our recent election law win at the Minnesota Supreme Court and on other cases, so thanks for being here.
Thanks for having me. It's good to be here. As I say, a long-time listener, first-time caller.
Appreciate that. So let's dive into some of the cases, and there are too many to cover in real great detail, so we'll do as much as we can to let our listeners and our viewers get clued in on what's happened in the courts, and we'll see what we can put together.
Great.
All right, so first we're going to start out with a case called Lowe versus Walz, and this is a case where Northwestern and Crown College, as two Christian universities, were actually disqualified from the state's post-secondary education enrollment options program because they have a Christian faith statement requirement for on-campus students. And now this is not like they're teaching math, or they're not teaching theology in these classes. They're teaching math and science classes for high school students who just want to go to a Christian university to get those credits. And now the U.S. Supreme Court has struck down at least two laws just like the trifecta's law in the last couple of years. It just seems crazy to me that the state of Minnesota not only has passed this law, but that they're defending it very vigorously in court, despite originally agreeing to an injunction against the implementation of the law while the case is ongoing. Do you want to talk a little bit about this, Ryan?
Right, and of course, we talk a lot about the Democrat trifecta here in Minnesota, but there's been a trifecta of Supreme Court cases on this very issue, starting with Trinity Lutheran, then Espinoza, and then most recently in Carson. The Supreme Court couldn't be more clear that this type of discrimination place public benefits, discriminating for the purpose of, just because they're a religious entity, as they said, odious to our Constitution, right? Type of discrimination.
Yeah, it is. Yeah, and in the Espinoza case, the court basically says, look, you can have you can decide not to engage with private entities in the first place as the government. But once you open up a benefit to all private entities, you can't discriminate between private entities based on whether one is religious or not religious. A clear violation of the First Amendment.
Right, and we saw that in the most recent case, Carson case as well, right? In Maine, not every area has a public school, and so they would give parents, in essence, vouchers to be able to go choose a public school of their choice.
Right.
But they expressly excluded religious schools in that case. I'm simplifying a lot of this, but what they said is, you cannot discriminate against religion. It's as plain as that.
Yeah,
and so,
exactly.
Again, in these three cases, the court could have been more clear. So it is surprising that they continue to defend what is a pretty blatant unconstitutional law here.
Yeah, and I think they're currently, as we speak, preparing for an argument on summary judgment. The parties have cross-moved for summary judgment, both sides asking the court to say, hey, we win, they lose. And it seems like it's a foregone conclusion, in my mind at least, that the court should come down on the side of the Northwestern and Crown colleges because, again, you have a trifecta of Supreme Court cases, as you pointed out, that clearly say that once you open up government programs to all private entities, you can't discriminate across religious beliefs. So pretty straightforward. But this kind of reminds me, by the way, of Upper Midwest Law Center has this ongoing case where we represent Tony Schmidt against the Department of Corrections officials because they canceled his prison ministry, his Christian prison ministry, on the exact grounds that it contradicts the department's supposed DEI values. And, they allow all kinds of other religious programs in that apparently pass the government's religious establishment test. And it's just inappropriate. It's just a consistent thing, though, across the state of Minnesota. There's this kind of animosity toward religion that we see. We'll move on in the list here to the next case that I've got here, which is an Upper Midwest Law Center in conjunction with Pacific Legal Foundation case called Nistler versus Walls. And this is a case where we at the Upper Midwest Law Center and Pacific Legal Foundation filed a lawsuit because one of the 2023 laws provided that the state would give out down payment assistance grants to people who want to become farmers. And
it's a good idea.
It's a great idea, right? It's a great idea. But then what they did was they said, but you'll go to the top of the list. You go to the front of the line if you are a minority, if you are someone who fits these categories of race. And yeah, I think the Supreme Court said it really clearly just a few years back when it said the way to stop discriminating against people based on race is to stop discriminating based on race. This is not a very difficult concept, I think. And yet the state had this provision in place that provided that emerging farmers were going to be prioritized. And so our client, Lance Nistler, actually, he won the lottery, so to speak. He ended up in the top of the lottery picks, and he was eligible with the first run of the lottery to get one of those grants. But because he was a white male, he was then put to the bottom of the lottery. And, lo and behold, even this was a bridge too far, maybe, for the state of Minnesota, because in the 2024 session, after we filed this lawsuit, the legislature actually changed the definition to get rid of the overtly race-based classification. And Ryan, this is the kind of thing, you see these kinds of things across the law in a lot of different realms. And it is just so wrong that the government continues to want to discriminate based on race.
And of course, the Supreme Court couldn't be more clear. This type of equal opportunity denied just can't stand in our law, right? We cannot have these kinds of race-based discrimination,
right,
in any direction. Again, whether it be we've seen it in private schools, we've seen it in more recent affirmative action cases. We've seen it across the board. The Supreme Court has been clear that, as you said, the best way to stop discriminating is to stop discriminating. And I think this case showed. This case obviously settled or changed or resolved quickly. When the trifecta first came about, there were a lot of questions about what next, what happens to people that may be more conservative-minded or more originalists in their constitutional views, or want to uphold what they view as the law, because there wasn't going to be a lot of recourse to the legislature.
Right.
There was going to be recourse to the courts, and that's one of the great things the Upper Midwest Law Center has been doing, is really going to that third branch that's there to be the last bastion of hope and protection against our rights being infringed on. And again, this is a great example where you guys were able to bring that case and get a resolution.
Yeah, thanks for that. And every now and then, as I always say, is there's never a harm in talking to the government and explaining, here's the position, here's what's going on, and asking them to do the right thing. Every now and then they surprise you and actually do it. So thanks for that. I appreciate your kind words there. And I do think that's one of our goals at Upper Midwest Law Center is to be a last bastion, to be a last line of defense against unconstitutional behavior, plain and simple. And the idea is we're not bringing cases to try to get some gerrymandered precedent. The kind of idea is the Constitution says you must be race blind. The Constitution overtly rejects the critical race theory view, the anti-racism view, which is a bad phrase in the first place. The idea that you have to discriminate today to get rid of discrimination that happened in the past. We can recognize past discrimination, but the law does not allow you to continue it into the present. And it certainly doesn't allow it for the future. And so that's why we bring cases seeking an injunction, seeking a court order stopping this kind of thing from happening. So thank you for your words.
Great outcome.
It was a great outcome. And thanks to Pacific Legal Foundation for spearheading the effort, because they were lead counsel in the case, and we want to give them credit when it's due. Another case we have here is Minnesota Chamber of Commerce versus Choi. And John Choi is the Ramsey County attorney who would just be charged with the enforcement of the law. Sometimes one of the things that our listeners and viewers might not know is that sometimes you have a county attorney who may not himself have done anything in particular related to that law, but they're charged with the enforcement of the law. So the person you have to sue is a person who actually could enforce it, who is actually chilling your speech, who is causing your First Amendment violation, even if they haven't actually already taken an action against you. So in this case, the Ramsey County attorney is the lead defendant. But what happened with the Minnesota Chamber of Commerce case, the legislature passes a law, and really what it sought to do is an end around on the Citizens United decision from the Supreme Court from 2010. Now, there's been a whole lot of complaining and bellyaching about Citizens United ever since it started in 2010. But one of the things about Citizens United is that it allows everyone to make independent expenditures to donate to PACs in an unlimited amount. And it does, if you're a U.S. citizen, and it does so in a way that benefits both sides of the political aisle. It is a viewpoint neutral law that allows, it's not a law, but it's a decision that allows for a viewpoint neutral spending on speech.
And probably one of the most misunderstood and misconstrued court decisions in the last 15 years, right? It really became a boogeyman for the left in terms of for what type of what they believe were excesses of the Supreme Court. In there, they discuss this. So this case, I'll let you finish the case, but it touches on whether the amount of foreign control or foreign ownership that can be allowed, and people still invest or still participate in our elections. Why don't you finish, and I'll come back and have some comments about that.
Oh yeah, sure. So what essentially what happened here is that the law bans a company from making donations to any independent PAC where a single non-U.S. person owns 1% or more of the company, or where 2 or more foreign investors in aggregate hold 5% or more of the company. And really what this is designed to do is to scare people who have lots of different investors from being involved in politics in the first place. And it really does feel like it's an attempt to openly defy the U.S. Supreme Court from Citizens United.
Especially because of the nature of how corporations are owned nowadays.
Right.
Publicly traded corporations, their ownership can change on a daily basis.
Absolutely.
And it really becomes impractical, as they argue, to be able to administer this type of law, especially with such a de minimis amount of foreign ownership being the trigger to prevent corporations from exercising their owners' constitutional rights.
Right, and not only that, but so what's amazing about this law, and this is all in the conference committees and on the House floor, is that it exempts labor organizations. So, labor organizations, for example, the Service Employees International Union, right? Unions have consistently had members and other contributors who are outside of the United States, and yet they are not called within the ambit of this law. And so I think that's one of the things that the Chamber of Commerce points out in the lawsuit, too.
And of course, on these First Amendment challenges, one of the things that the court will weigh is whether it's over-inclusive and under-inclusive.
Right,
and
exactly.
Over-inclusive means, does it sweep in too much lawful speech, right? Is there too much good speech that this ends up excluding? And there's a whole lot of speech that that ends up being swept in here as well. But on the under-inclusive, to that point, when you have labor unions or other types of partnerships could be formed, or other types of entities that aren't the corporate form, that are not being regulated by this statute, you're really under-inclusive because you're not attacking the necessary problem. So it really looks like it is gerrymandered towards a specific group of people. Yeah, exactly.
And the First Amendment requires strict scrutiny on anytime you're chilling the speech of one group over another one. And this is where, it is really, really important that laws that are written to restrict speech in some way, shape, or form, we'll talk about some more of those in a few minutes here, but those laws have to be written narrowly tailored, and they have to have a really serious government interest, because the First Amendment is so important. That's why it's the first one in our Constitution. And when, as you mentioned, if something is under-inclusive, that means it's not including the whole universe of different types of speech that would actually cause the harm the government claims exists. That shows that they're not really so serious about fixing the harm. They're serious about putting their thumb on the scales on one side or another. And that's definitely what's happening here in my mind.
And really, it does appear to be an attempt to end around Citizens United, stopping corporations from speaking. And on that, one of the arguments early on was corporations shouldn't have constitutional rights. Right. And corporations, as many people know, are a collection of individuals that came together and decided to undertake a particular venture under the corporate form. There's other forms of businesses as well. But one of the issues with that is, if you take that to its extreme, if the Constitution can never protect activities of a corporation, well, could you ban a newspaper as a corporation? Right. Any for-profit corporations.
Exactly.
Could you ban a newspaper from printing something that you don't like them printing, and do they have no First Amendment rights because of that? Clearly not, right?
No, of course not.
And so the idea that corporations, have no rights, and divorcing that completely from the fact that corporations are collections of individuals, it just doesn't hold water.
Right, and at the founding, as the Citizens United case itself pointed out, corporations have been speaking since before this country was ever formed. So the idea that the founders would have thought that corporations have no speech rights is just wrong. So the parties now, in this case, there's actually another injunction. I don't want to bury the lead here too much. December of last year, just under a year ago, the district court in Minnesota actually issued a preliminary injunction against this law because it said the chamber is likely to prevail on the merits of the case. So the law had no effect for the 2024 election in the first place. And the parties have now gone through discovery and filed briefs at the court asking for judgment to be entered in their favor on each side, similar to the case we just talked about, the Lowe versus Walls case. An argument took place on October 15th in that case. So we should expect a decision, I think, in the next couple of months. Moving on to the next topic on our list here. Next case is Association for Accessible Medicines versus Ellison. Now, this one is about controlling prescription drug price increases, essentially. So the Association for Accessible Medicines is a national trade group which represents manufacturers and distributors of generic and biosimilar medicines. They sued Attorney General Ellison because of a law passed again in 2023, which forbade drug manufacturers from imposing so-called excessive price increases on generic drugs based on what the state health commissioner says is excessive. And this is a case in which, again, last year, about a year ago, almost to the date, the federal district court in Minnesota issued yet another preliminary injunction against this law because the law reaches way beyond Minnesota. And it seeks to penalize manufacturers who might raise generic drug prices even if they're manufactured for potentially in Colorado, shipped to a distributor in New Jersey, just because it might eventually be sold into the state of Minnesota. And so this is where Minnesota is reaching beyond its territorial jurisdiction, and that's where the dormant commerce clause of the Constitution stops this from happening. And so the government has appealed the grant of this motion in the 8th Circuit, and the case actually still remains in the 8th Circuit at the moment. It was actually argued to the 8th Circuit just about a month and change ago on October 23rd of this year. So I expect a decision on whether the 8th Circuit is going to uphold this injunction in the next couple of months.
You know, of course, one of the things the lower court discussed here, and it was argued, was that this isn't just about Minnesota trying to regulate prices set in Minnesota.
Right.
Because this includes in the sweepstand drugs that are potentially shipped in from out of state or other places that the price increase might occur.
Right.
Obviously, this is Minnesota reaching beyond its borders.
Right.
And as you said, then it implicates the dormant commerce clause. This idea that state protectionism, that states can't try to protect their own interests at the expense of their neighbors.
Exactly.
So dormant commerce clause, it's a great tool, again, for protecting against this kind of state protectionism. It does have its critics, though. Justice
sure does.
Scalia, Justice Thomas, to get this right, I think they called the doctrine of judicial fraud. It's something they didn't see in their originalist interpretation of the Constitution. They'd like to see, Congress and the Commerce Clause really doing the heavy lifting there, as opposed to the Dormant Commerce Clause, where Congress has not yet acted doing the lifting for them. And there is some, I think, wisdom to that, which is that if Congress wants to ensure uniformity across the states, they have the opportunity to regulate that.
That's true. They do have the opportunity to regulate it. It's not explicitly in the text of the Commerce Clause, which is, I think, the greatest problem from a textualist perspective. Yeah, there are those who favor this, of course, those who believe, in the idea that the United States was created so there wouldn't be this kind of warring factions between different states and people increasing and protectionist price increases or decreases or whatever, what have you. Depending on what state you're in. But what this really shows a problem with, and there's been a couple cases now, including cases that the Attorney General in Minnesota has brought against energy companies, where this is an example, I think, of Minnesota trying to be the tail wagging the dog, right? They're trying to affect the national market for drugs, generic drugs, prescription drugs, by passing a law that reaches outside of our borders, so that drug manufacturers are basically forced that if they want to use this market, if they have to control drugs in the stream of commerce, they have to make a change on a nationwide basis. And the same thing has happened with, essentially these lawsuits from the Attorney General suing energy companies like Koch Industries, like Flint Hills, and other organizations saying, oh, you didn't tell people about that oil was going to cause climate change at some point, and that's somehow consumer fraud, which is, to me, an absurd case. But beyond that, I mean, it's an attempt by the state to control what national oil and gas manufacturers are doing. And I see no difference between the type of tactics we're talking about here.
And of course, there we've seen, I believe it was North Dakota, right, that's threatened to sue Minnesota,
right,
over some of, not on our list here to discuss today, but
right,
maybe another lawsuit coming for a future trifecta update.
It might be. We'll move on to the next one on the list, which is another case that UMLC is involved in. We've teamed up with the Hamilton Lincoln Law Institute in the Christopher Coles and Mary Franzen against Ellison case. Now, this is related to Minnesota's ban on political deepfakes. So our clients, Upper Midwest Law Center's clients, are Christopher Coles, who runs an X account named Mr. Reagan USA, and State Representative Mary Franzen, who likes his content and sometimes likes to share memes. And the new state law essentially bans political speech that uses AI-generated deepfake technology to create a moving picture, that supposedly portrays a politician in a false light.
So does include parody?
Exactly. So the ban includes political satire, which is what the lawsuit is really aimed at. And Mr. Reagan, as he's known, has used this exact type of technology to create a meme that makes fun of Kamala Harris, who lost to Donald Trump in the 2024 election. And so in this case, the plaintiffs, represented by us at Upper Midwest Law Center and the Hamilton Lincoln Law Institute, moved for a preliminary injunction seeking to have the law set aside. And that motion will be heard in federal court and is coming up here on December 17th.
And of course, political speech is some of the most protected speech that we have because it goes to the core of our republic, right? And who we elect and how we elect them and what we say about them. And so I know the court has will have a lot of scrutiny over this. When again, back to First Amendment, under-inclusive, over-inclusive.
Exactly.
And I assume there are redeemable parts of this law.
Absolutely. Yes.
But again, the law goes too far and sweeps in too much work. Now, if I remember, is this the case where the expert put in a declaration that itself ended up being a deep fake, or
yes,
or including some to maybe enlighten the viewers for what happened there?
Yeah. So this is a really bizarre turn of events. So the state, of course, is defending a law. That law bans certain speech that is based on AI-generated content. The expert witness that they put an expert witness's sworn statement in the record to defend the law against our motion. That expert witness's declaration used AI hallucinated studies as a basis for demonstrating that, yes, we need a law to paternalistically tell people, nanny people's right to see different types of speech.
And so how was that, in this case, how was that caught? Do you need a law to be able to catch that deep fake?
No, amazing. My co-counsel, Frank Bednarz, in this case, just happened to do his due diligence and read through the papers and found this study. And then after he found this study, he pointed out to the court in a motion to exclude this expert because the expert's testimony is obviously unreliable based on false testimony. And we filed the motion to exclude, raising this issue. And then actually Professor Eugene Volokh actually went and found another study that was also hallucinated in the same document. And then the expert actually just came back with a proposal to amend his previous declaration. And in that amendment,
not withdraw it or not?
Not withdraw it, even though, again, it's based on false testimony. It's pretty clear to me that the duty, at least the attorneys continuing to put this declaration forward, have a duty to withdraw this. And it hasn't happened yet, which is very surprising that the Attorney General's office has not withdrawn this. It's like they want to have their cake and eat it too. They want this declaration to stay in the record as long as they need it to be there. And then if they can get it amended and switched out, then great. And if not, they still want to be able to rely on it somehow. And maybe at the last minute, they'll be forced to withdraw it if they absolutely have to. That's not how the duty of candor works. You're, as an attorney, you have an obligation to pull back on this information and withdraw it. And then if you want to resubmit it later, even if it's going to be late, that's on you. You don't get to have your cake and eat it too, like they're trying to do. So it's really disappointing to see what the Attorney General's office, how they prosecuted this particular instance. And look, if the shoe were on the other foot, and we had used something like that, and an expert witness had done something like this, and we didn't know about it, and it was, innocent, and our office didn't mean to do it, we'd withdraw it. You immediately withdraw it. And I can't imagine the type of reaction of the Attorney General's office.
You wouldn't continue to defend fake studies, right?
No. And I can't imagine the reaction that my opposing counsel would have if I were trying to do what they're doing on the other side. It is just crazy. And we're looking forward. The court just yesterday actually decided that all the motions to exclude the expert and the motion on the injunction itself and their motion to amend to switch in this new expert report that they want to put in are all going to be heard at the exact same time, which is what we had been asking for. So we're happy that that's going to happen. So we'll see how it goes. I think there's a very good chance that as it relates to political satire, this law is going to get enjoined. I think it's a pretty good chance. On the next one, we've got another law, Minnesota Voters Alliance versus Ellison, another UMLC case. Another law has been challenged, again, a trifecta law, related to speech on voter eligibility. Now, we sued over this last September, and what the law does is it claims to ban supposed false speech about voter eligibility. But what it really does is it gives political opponents a license to sue people to shut them down from talking about voter eligibility issues if they disagree.
So give me for example.
Yeah, so the example is this. The Minnesota Constitution says that felons who have not been restored to civil rights cannot vote. Article 7, Section 1. Yet the legislature last year passed another law that says that felons who are out of jail and who haven't completed their sentence have the civil right to vote restored. That's just one.
But not all their civil rights.
Not all their civil rights. Not all.
To go back to you quoted the Constitution, it was civil rights.
Plural. The Constitution says that they have to have their civil rights, plural, restored. The legislature tried to restore just the one civil right, the civil right to vote. But so Minnesota Voters Alliance and the other plaintiffs in the case said that's not right. The law didn't properly restore the right for felons to vote. And so this law that we're really talking about, that's the underlying premise here. So our clients want to be able to say, as a matter of their own political persuasion, in Minnesota, felons are not eligible to vote unless they've been restored to all the civil rights they lost when they were convicted. And so the law is ineffective. So felons cannot vote under the Constitution as a result of that.
And of course, our Supreme Court, the highest law of the land here, has not decided, we'll get to that in a second, but they have not decided that issue. So it's not like this is false speech, which itself, you're allowed to say false things, right? But
yeah.
And you can get corrected by people that want to correct it with true speech. But this is really an open question that they're wanting to discuss.
Exactly. And that's exactly the point, is that there are issues of matters of public concern, right? Issues of what the law means, issues of what is an effective law, what is an ineffective law. And look, the statute is passed. There's a lot of people who committed felonies, who are convicted, who have not finished their sentences, who have not been discharged, who voted in the 2024 election. We know that, Steve Simon said there were like 55,000 people who were in this category. And who knows if some of those people might have voted in elections that were decided by potentially 14 votes, potentially, 25 votes or 100 votes. We know that there are specific examples. We have an election contest going on with a 14-vote margin. Who knows? Those votes can shift elections. And so it's very important that voter eligibility issues are decided with finality and clarity and according to the Constitution. So that's what Minnesota Voters Alliance has advocated. And we'll talk about the other lawsuit related to that in a minute. But what this speech law says is, no, you can't talk about that, really. I mean, it doesn't specifically say, Minnesota Voters Alliance can't talk about this. But what it does is it allows someone who has maybe more money than they do, who has the time to burn to do it, who happens to be the attorney general or a county attorney who doesn't like what they're saying, to bring them into court and claim you made false statements about these people's voter eligibility. And it even allows someone who is any person who claims to somehow be harmed by our client's speech to pull them into court. To defend themselves.
Beyond this speech, that seems to sure kind of a chilling effect, right?
And that's the point. Yeah, exactly. It's a chilling effect on speech. And it's a chilling effect, there are constitutional prohibitions, for example, on people who are non-citizens voting. So if Minnesota passes a law that says non-citizens can vote, and the Constitution clearly forbids that, does that mean that non-citizens can suddenly vote? If Minnesota passes a law that says 16-year-olds can vote, and the Constitution says you must be 18, does that mean that it's false, that someone can pull you into court? Because technically, as long as the statute's in place, those people can vote, right? At least that's the argument made by the government, is that, well, your speech is technically false because the statute says they can, and so they do. Does that mean that it's still legal? No, the Constitution of Minnesota is the supreme law of the land in Minnesota. And so making the statement that the Constitution essentially is supreme shouldn't be controversial, but some people would consider it to be. And that's why you can't have laws that allow you to haul other people into court in order to force them to defend their speech. And I know this because back in 2013 and 2014, I was on the team that wrote the briefs and argued the hearing in the 8th Circuit Court of Appeals in a case called 281 Care Committee versus Arneson. In that case, the 8th Circuit said, and that's controlling law in this circuit, said that if you have a law that says you can't make a false statement about the effect of a ballot question, that's unconstitutional to ban that kind of speech. Even if your political opponent thinks it's false, so you challenge a school referendum or something like that and say this is going to raise your taxes, and someone says, no, you're a liar, I'm taking you into court. You can't do that under the First Amendment. In the same way, same thing with voter eligibility. There's no harm that's being addressed here that is necessary to be addressed.
So, of course, what's the better remedy if somebody's making a false statement about whether it be the school board election or something? What would be?
Look it up. Do your research.
Yes.
As much maligned in the mainstream media today as someone did their research and so there's misinformation there. Well, guess what? This is a marketplace of ideas we live in, and that's what should be happening. We should have a robust public debate in the marketplace of ideas. If there is speech that is verifiably false, people can figure that out for themselves. They don't need a nanny.
For example, if there's a fake study cited in the report.
Yeah. Yes, any fake studies. All you got to do is read to figure out whether or not it's real or not, because the internet does not lie about this stuff. It's out there somewhere. So moving on, then the underlying case, and we're not going to talk much more about it. Just to say this. The felon voting case itself. Again, Upper Midwest Law Center challenged, representing Minnesota Voters Alliance, challenged the law that purportedly restores the right of felons to vote in Minnesota elections before they've been restored to all their lost civil rights. And what happened in this case was just so frustrating to me, because I still think we're right on the merits. I agree with Minnesota Voters Alliance that felons cannot vote in Minnesota elections unless they're restored to all their civil rights lost, and they haven't been by this law. That's my interpretation of the Constitution. I think it's a good faith interpretation.
Be careful. You may have just broke the law.
Well, and I would say, bring it. The fact is that the Supreme Court of Minnesota had an opportunity to address this. We went to the Anoka County Court. The court disagreed with us. The Minnesota Supreme Court agreed to take the case on accelerated review, had the case fully briefed, had parties from all sides putting their input in, amicus curiae and all sorts of places. And the court decided, instead of dealing with the merits, which is why we still have uncertainty as to what the Minnesota Constitution means, the court decided not to deal with the merits. The court decided that Minnesota Voters Alliance and the individuals who are taxpayers of Minnesota don't have an interest in suing to prevent the legislature from passing an unconstitutional law that affects all citizens by allowing people to vote in elections where they don't actually have the right to vote.
And I think this is important for the viewers here to understand this, and that they did not reach the merits of that case. We saw the a lot of members of the media report, and then regular citizens then parrot that this was a loss, and that felons do have a right to vote, and that's what the Supreme Court said. And they did not say that.
They did not.
That's
say
false speech.
That is false speech. Yes. That's bad reporting, is what that is, or a misunderstanding of the law in general.
And some of these cases, it is hard to find standing. But in this case, I think something important happened beyond just whether not reaching your particular issues here. Our federal courts, by design, have narrower doors,
yes,
and have cases and controversy requirements to be able to bring lawsuits there. Our state courts, by design, our courts of general jurisdiction, they're meant to be more open, right? You're able to bring more cause of action. Minnesota historically has had a looser taxpayer standing requirement than the federal courts.
Yes,
and maybe talk a little bit about that. And what the implications of this case are going to be on people of all persuasions wanting to bring challenges.
Well, right. I mean, the idea Minnesota has always had, especially ever since a case called McKee versus Likens, I think it was 1973, has had this doctrine of taxpayer standing, where if you can show that there's been basically an illegal use of your tax dollars, by whether that's through an expenditure or an appropriation or something like that, you go into court to challenge it. And you don't have to have a special injury that's different from the population at large. It just has to be that your tax dollars are being used for this purpose. And what we pointed out to the Supreme Court in this case, in the felon voting case, was, in fact, this law appropriated tens of thousands of dollars to implement its provisions. Now, they say, well, that the money wasn't really spent on changing the voter rolls over and allowing someone who's a felon to vote. Well, I mean, we're really hair splitting there to deny people the ability to bring legitimate challenges based on good faith arguments about what the Minnesota Constitution means and what the people's rights are under the Minnesota Constitution. And the problem, of course, is that you in terms of the voting, in terms of election law, is that you can always bring a challenge if you've been deprived, as some might put it, of the right to vote because of your status as this, that, or the other thing. You're a 16-year-old. Oh, well, you're not allowed to vote, so you have standing. Whether or not you have a meritorious argument or not is a different question. The argument can be made. you have standing to go into court because you have an injury, because you cannot vote. But the people who say, hold on a second, I don't want my tax dollars being used to implement illegal voting laws that are unconstitutional, according to the Supreme Court, they don't have any remedy. And that to me, you know, and the court suggested in some places during the hearing, at least one of the justices did at least, that maybe these kinds of issues should be brought up in election challenges. And I thought I was answering her question at the time, and I just thought, boy, I thought we just got through 2020 and we didn't want to have a bunch of election challenges. Why don't we deal with these things out in the open, out front, away from the election contest where the temperature is a little bit lower, where people don't have quite as much at stake, where we can actually have a robust discussion and decide it with a cool, level head. It just seems to me that it's a one-way ratchet, really.
Well, and of course, we have 2 election challenges happening right now.
Exactly.
Under 209. Now, the issue with that is there's a small period to be able to bring those challenges, right? 7 days. And so to be able to go and find that a certain number of felons voted during that time, it's just not practical to be able to add that to this particular lawsuit. But I see the merits of what the justice was offering there, which is that would be a place to bring it, theoretically, but practically very hard to do.
Yeah, practically very hard to do. You'd have to get immediate discovery from the Secretary of State probably to get the information on, and probably from the counties themselves. Because by the way, the counties' voter rolls, as I understand it, they're not actually updated until January 14th of next year. So even if you wanted to bring an election challenge, people are already sitting in their seats at that point. You wouldn't be able to get that information, the updates to the statewide voter registration list, until after the time for a challenge would run. And as you and I both know from just knowing just general stuff about election law in Minnesota and how the government operates when you sue the government, it's that if the day before the election, the case is not ripe, meaning you don't have a case and you can't come into court, and the day of, nothing's happened yet, the day after it's moot. And so you can't bring a case because it's too late now. And that latches apply and things like, all these made up.
These are all tools, obviously. There's the tools that the government uses to reach anything but the merits in these cases because, you wouldn't bring an unmeritorious case. And so,
of course.
Again, these other jurisdictional arguments are what have to be, hopefully advanced. And obviously in this case, the court accepted that argument on standing. So.
Yeah, unfortunately, in this case, that's where the court came out, and I think at some point
we live to fight another day. I mean, it's still an open question.
Yeah,
and if you can find the right client, the right standing, the right set of facts, there may be an opportunity.
And what I'm just going to suggest is that it might be worthwhile that if there's going to be this one-way ratchet on election law, that the legislature could easily create a remedy specific to election-related issues in Minnesota's election law, allowing for individuals to go into court and challenge when a law is unconstitutional, regardless of whether or not they have been deprived of the right to vote. Because Minnesota, as you mentioned before, is not a federal court. They are courts of general jurisdiction, and they have the jurisdiction that the legislature confers on them and what's conferred upon them by the Constitution, generally speaking. So the legislature can create causes of action that would allow for specific election law challenges to be made, that would allow for these decisions to be made without hemming and hawing about what the court's prudential standing is.
This next case is a case brought by United Health Group regarding the single subject and title clause of the Minnesota Constitution. So the Minnesota Constitution requires laws have only a single subject to prevent log rolling and throwing a bunch of unrelated bills together, forcing an up or down vote. And you can understand the wisdom of something like that.
Absolutely.
We want to know what our legislators voted for, and we want to know why so we can hold them accountable why they voted for it. And so what happened at the end of was the 23 session?
Yeah, 24 session.
24 session. A massive omnibus bill. Omnibus meaning they just put everything together into one large bill. And I think the title of this bill alone, just the title, was something like 10 plus pages. Yeah. The attorneys here for United Health Group did a phenomenal job laying out just the excesses in this bill, really unlike any other in history. And there's all kinds of nicknames that they've used for this omnibus bill.
By the way, I think they were really nice, and they called it the jumbo omnibus bill in their briefs. I might have called it something a little bit more pejorative.
It's a bit charitable. So this bill includes all kinds of unrelated things. Maybe touch a little bit on some of the things in there. MMA fighting being one of them.
So it requires health insurers to cover abortion is part of their plans for every company who has a group health plan in Minnesota, unless they have a very specific religious objection to it. So even if you have a moral objection, it's not necessarily going to be covered.
Okay, so there's a single subject rule. You can only have one subject in the law. So this whole law must be about abortion then?
No, exactly. It's not. It also makes it illegal to have what's called a binary trigger for a gun. Now, guns and abortion don't have anything to do with one another at all. And the meat and potatoes of this bill, of course, is taxes. It was a tax bill. It was originally called the Omnibus Tax Bill.
So they're taxing binary triggers.
No, they're not. No, they're actually outright banning them, and they're making it a felony to possess one.
So it's not a tax bill.
Not a tax bill.
Not a gun bill.
Not a gun bill, not an abortion bill. I'm not sure what bills. How about MMA fighting you mentioned? Certain rules and laws related to combat sports. How about transportation network companies, TNCs? Uber and Lyft are also regulated in here. Reclassifying workers as independent contractors versus employees is also covered in here. This bill covers so many different substantive subjects that it is totally unrecognizable in terms of what a single subject might be. There is no single subject to this law, which is why the court should strike it entirely and not just parts of it.
And so the courts over the years, this is something that's been applied for over 100 years in Minnesota.
Yeah.
And they've the remedy to this type of log rolling and single subject has changed over time. Maybe talk a little about that.
Yeah.
Where the current state of the law is. What should the court do here? What has it done and what should it do?
Well, I think the original meaning of the Minnesota Constitution is that because it's designed to prevent log rolling, if you violate the single subject and title clause, the entire bill has to be struck. And so the legislature needs to start back at square one. And they can do that by bipartisan compromise with this next session if they so choose. The court striking this down would not deal some major blow to Minnesota. In fact, it would be very helpful for Minnesota if the court were to strike this down eventually, the Minnesota Supreme Court, I mean. But now, ever since 2000, in a case called Associated Builders and Contractors versus Ventura, the Supreme Court has decided basically that if an individual who has standing comes in and sues over a particular provision of the law, that provision gets struck. But in that case, there was a concurrence by Justice Paul H. Anderson, and I think he's right, which is that the whole thing needs to be struck if you fail it for the exact reasons I already gave. It's designed to be an anti-log rolling measure. It's designed so that the people of Minnesota deserve to know what their legislators actually voted up or down. It's not fair for the people of Minnesota, for their legislators to be voting on these massive omnibus bills where they don't really know where the legislator truly stood on an issue, because then you have people who will say on the flip side, I won't vote for any omnibus bill because I don't want my record to be shown that I voted for some government increase that I disagreed with because it was part of a compromise to get this larger omnibus bill through. So the Constitution was written to prevent that from happening, to prevent people from having to deal with these kinds of back and forth. And until recent years, until more modern precedent, omnibus bills were not that common. They had some omnibus bills, and they were truly single subject, but as a regular session, you can look on the reviser's website, look at all the session laws from the 80s and 90s even, and they'll have 800, 900 laws that were passed during the session, bipartisan compromises or not. They would be on a single subject. They'd be 1 or 2 pages, easily to understand. What did my legislator vote on that? I can figure it out if I'm a person who wants to know whether I should vote for that person again. Not so anymore. Now you have these massive things where you have legislators who say, well, I really disagree with all this stuff, but I got to vote for this because I really think that's important for my jurisdiction to get this particular law passed to, make sure that they can do X, Y, or Z. So there's a whole lot of reasons why, from a public policy standpoint, the Minnesota Supreme Court should come in and wipe out this whole thing. But one thing is for sure, and United Health Group has pointed this out really well. There is absolutely no single subject here. There is absolutely no single subject here. And their subject, and the state, by the way, came out with this idea, well, we're just going to say it relates to state government taxation and spending, essentially, funding and spending. It's like the broadest possible topic you can think of. But also, it's not you don't defer to the state as to what they think it is. The court should be looking at it and saying from a neutral arbiter's perspective, what does the subject of this bill, what actually is it? And if you can't say what the subject is with clarity, the whole thing should be.
Of course, there's a century of case law where these types of things have happened in the past that will run contrary to the government's broad view of what the subject should be.
Eventually, this case is going to get to the Minnesota Supreme Court because what happened here so far, by the way, is that United Health Group moved for a temporary restraining order. The court denied it, essentially because they couldn't show irreparable harm because the state decided to cancel certain Medicaid, Medicare contracts they had, and they had, according to the court, the state had a right to do that regardless of the omnibus bill. Whether I agree with that or not, I don't know. But what the court did say is, as it relates to the single subject and title provision, that there was a fair likelihood of success, more than just a small chance of success. And I think that's what's going to happen here is that the court's eventually going to find that for United Health Group's case, that they are correct on the merits, and that the provisions that they are specifically challenging will get struck down. And it's up to the but I think it's up to the Minnesota Supreme Court to actually take the wider view and say, enough is enough. We can't do this again. Look at the rancor and the turmoil this caused at the end of the last session. This should never happen. Moving on to the next case is American Alliance for Equal Rights versus Walz. This is where the American Alliance for Equal Rights, represented by the Pacific Legal Foundation, sued Governor Walz because his appointments to the Board of Social Work, of all things, requires at least 5 of 15 members to be from a, quote, community of color or a, quote, underrepresented community. And so this is really just a code for gerrymandering. Gerrymandering appointments to a board based on race, and it really has no place under the 14th Amendment.
We talked about this earlier, but this seems to be a theme in the legislature as of late, which is continuing to inject race into our laws. Does it surprise you just the degree to which we're seeing this across the board?
No, and to be fair, this law was amended in 2020. It's the last time it was amended. So this is not a specific trifecta law, but it is part and parcel of the legislature's bent over the last, 12 years, 13 years at least, where a lot of these types of race-based classifications and race-based requirements, quotas, which have been, quotas have been banned since the Supreme Court decided the Backey case back in 1978, related to Southern California. And so this lawsuit was brought in May 2024. This is an important broadside by the Pacific Legal Foundation and their client against Minnesota's apparent love for racial division based on quotas. And the trifecta did pass a lot of those racial divisions.
Okay.
So far in this case, the government has answered the complaint. They did not move to dismiss. So they want to go into discovery, and they want to figure out more on what the other side, what the plaintiff has in their pocket, as opposed to what they have to come forward with. And so the case is currently in the middle of the discovery process and probably will be there for a few more months. So we probably won't see anything coming out of this case for at least another 6 months to a year.
Is it federal court or state court?
Another federal court case, yeah. And that's a common theme, too, is that when the U.S. Constitution is involved, the federal courts have an unflagging obligation to adjudicate people's constitutional rights. The last one we're going to talk about today in any substance here is going to be the Minnesota Associated Builders and Contractors versus Ellison, the captive audience case, as it's called, challenge to the captive audience law. So this is a lawsuit that challenges a trifecta law. It bans employers from speaking to their employees about whether or not to join or support a union. So the unions can speak to them at will. Employers cannot. It's clear viewpoint discrimination. And so the law provides for civil penalties. But one of the reasons why this case is so striking to me is that Governor Walz himself, when he was on the campaign trail seeking the vice presidency, which he failed to get, he said that employers would go to jail now if they talk to their employees about unionization issues just for talking. That's another black mark on the state of Minnesota, courtesy of the trifecta and Governor Walz. Governor Walz might have been using a little bit of hyperbole when he made that statement on the campaign trail, but now it's in the complaint because he said it, and the plaintiffs amended the complaint to include that exact phrase in there.
What's the ill trying to be remedied here? Help me understand this law.
Well, the ill that this law is intended to remedy is to prevent the employer from having a captive audience of the employees and to prevent them from basically bullying employees into not joining a union because they think that's going to be bad for the bottom line for the company or whatever they want, whatever their reasoning may be.
But there's several federal protections against that already.
Oh, yeah. Absolutely. There's already the National Labor Relations Act, which specifically provides that you can't have undue influence as an employer, and you can't have undue influence and you can't interfere with employees' right to choose whether to unionize or not, or to be part of a union or not, on either side.
But it doesn't put a thumb on the scale of one particular speaker
Correct.
Or viewpoint over another.
Yeah, the National Labor Relations Act, as Doug Seaton cogently put on a recent podcast that we had here, is a compromise between trying to balance the interests between employees, employers, and unions. There's that kind of a triangle, and that is what the National Labor Relations Act is all about. So it already provides that kind of a balance. And Minnesota's Public Employee Labor Relations Act, similar to the National Labor Relations Act, also provides a balance, or did provide a balance. This law is meant to put a thumb on the scales in favor of the unions and against the companies, against the employers who don't have any right under this law to basically have a conversation with their employees in any kind of employer-sponsored meeting. And so what happened in this case is the state of Minnesota moved to dismiss, which is pretty common. And the district court actually denied the government's motion to dismiss from the bench on the issue of sovereign immunity. And I'm not really, I haven't read all the pleadings specifically on that one, but I have not seen a sovereign immunity motion denied from the bench before. However, the government has a right to appeal immunity decisions, so they're going to the 8th Circuit on that. In the meantime, though, the government is also trying to get a stay on the proceedings in the district court while the case is on appeal to the 8th Circuit. And the only justification for that I could see is one that's basically saying, we want to have this law in place as long as possible. We don't know what the court's going to eventually do with this, whether they're going to agree with us. We want to stop the proceedings so that it takes longer to get to the end. The tactic of justice delayed is justice denied is not a really good one, in my opinion, but the government does it a lot. So I think this case promises to go on for at least another year, as far as I can tell, and we'll see what comes out of it. So Ryan, we could probably keep going for another hour on all these issues, and we know of at least 2 other cases that we won't get into in detail here that challenge the recent trifecta's actions. Association of American Railroads versus Jacobson, related to a railroad freight assessment that also doesn't assess other forms of transportation like pipelines, and AbbVie Incorporated versus Ellison, which challenges a law that attempts to force drug manufacturers to deliver drugs to certain middlemen at certain prices. Again, another attempt to really gerrymander what drug manufacturers can do at the state level to affect their national models. We don't have the time to get into those further today, but needless to say, the trifecta's actions have met a substantial number of strong challenges in court.
You've been around a long time, as have I. Have you seen a session or sessions where this many constitutional challenges have been brought against, a set of laws passed? I mean, I can't remember in my lifetime seeing something to this extent.
I mean, I've never seen this kind of flurry of activity, and this is typically, maybe sadly, reflective of what happens when you have maybe an echo chamber in the legislature and you have one side passing laws on a one vote margin, even taking advantage of the vote of someone who is alleged to have committed crimes that would make her ineligible to serve in that capacity in the future, in that office. And no, I haven't seen anything like this before. And one of the topics and the themes, and we didn't get into, there's a lot more laws that we haven't talked about here today that make specific racial classifications, whether it's giving out money to people based on the color of their skin or ethnicity, whether it is giving choice positions or positions on a board like the Board of Social Work that Pacific Legal Foundation sued over, whether it's one of those situations. There's a lot of these kinds of evidence. There's a lot of these kinds of laws that are based on racial classification that the legislature passed in this trifecta. And again, all these laws that are based on a clear classification between people based on race are going to fall eventually in court when people come forward and say, hey, I've been discriminated against. I don't appreciate that. It's only a matter of time, really, and it's just going to mean more and more litigation unless the legislature comes in and fixes some of these race-based discrimination that they've created in the last couple of years. It's going to keep happening. Well, Ryan, all in all, while the governing trifecta celebrated, and as Governor Walz put it, burning a bunch of political capital, several of those legislative actions have fallen in court already, and the lawsuits have kept coming, as we predicted that they would. Perhaps a new legislature will see the folly of all this excess and undo some of these unconstitutional changes, but I wouldn't hold my breath. In the meantime, Upper Midwest Law Center and others who believe in the rule of law, who believe in our Constitution, will stand up for the people of Minnesota and continue to challenge those laws in court. And Ryan, I want to thank you for your time and your commentary today. Really appreciate you coming on the podcast and giving us your insights into these different cases. And thanks again for being here.
I want to thank you, and I want to thank the Upper Midwest Law Center. When this, again, I said earlier in this podcast that when the trifecta came about and it was clear there was going to be really unchecked single-party rule for at least 2 years, a lot of people ask, what is the hope? What do we do? And a big part of that hope, a big part of pushing back has been the Upper Midwest Law Center and the plaintiffs and the courageous plaintiffs the Upper Midwest Law Center finds and brings to be able to challenge these unconstitutional lawsuits. They don't happen in a vacuum. They don't happen by themselves. Somebody has to do the hard work of putting this together, advancing this through the courts and really standing up for Minnesotans' rights. So I just want to thank you and the Upper Midwest Law Center for all the great work you do for Minnesota, helping uphold our rights.
Well, thank you, Ryan. That's much appreciated. Really appreciate your kind remarks. And that's it for this week on Minnesota Law Report. You can learn more about the Upper Midwest Law Center by visiting umlc.org, and you can also make a confidential tax-deductible donation on our website or by sending us a check to 12600 Whitewater Drive, Suite 140, Minnetonka, Minnesota, 55343. And we would urge you to do that. We are fully donor-supported, and we charge our clients nothing. We are standing up for you in court and want to fight for you on every front. Help us to do more for you by making a donation today. Thank you, and we'll see you next time.